The system that we have in place right now has been there for decades. It works well. I don't know anyone that's at least practicing lawyers from either side or judges that have a concern that this process isn't fair.
Proposed changes to the criminal code have passed the third reading, but some lawyers are not happy with what's being suggested. One of the changes includes the removal of peremptory challenges, which allows lawyers to remove a potential juror without giving a reason. Legal experts are saying this is a knee-jerk reaction to the acquittal of a Saskatchewan farmer in the shooting death of a young Cree man by an all-white jury.
I've been practicing criminal law for 38 years. 10 as a prosecutor, 28 as defense counsel. And I've done I've defended a number, I've prosecuted a number of cases involving First Nations. And I can't remember having a First Nations person on the jury. And I never thought along the way that was unfair.
During the Gerald Stanley trial, visibly Indigenous potential jurors were released during the selection process, and then the verdict triggered backlash across the country, with calls being made for a change in the process. Many were appalled by an all-white jury, but Durr says he doesn't know if anyone who works in the courts has been consulted on these changes, and says it will just make it more difficult to find an impartial jury.
We know a person's name and we know their occupation. That's all we know about them. But from that, we can sometimes try to craft a jury or end up with a jury that we believe, from our perspective, whichever side they're looking at it from, is going to give us the fairest shot at the fair trial.
But Ottawa remains firm on this move. The federal justice minister says the removal of these challenges will make it so juries represent more of the Canadian population. In Calgary, Kristen Fong, City News.